Assalamualaikum warahmatullahi wabarakatuh to our respected lecturer, Dr. Anisha Haiza binti Muhammad Saleh and my fellow friends. So we are from Group 5 and we are going to present about the effect of marriage on status and property for non-Muslims. So before we get started, let me to introduce myself and my group mates. My name is Muhammad Iqmar Rahman bin Sidi and my message number is 281 and 519. I am the leader for our team. So as for my part, I'm going to explain about the classification and the definition between status and property by using the Section 2 and also Section 4 of Married Women Act 1957. The second presenter will be Ainur Izzah Balkis binti Sazli and her matrix number is 281 and 431, and she's going to explain about the Section 4A and the case, and will be discussing about the case of Yeo Bei Lin versus Lee Eng Chi. And third presenter will be Anisha Mila binti Nazri and matrix number is 281 and 439, and she's going to discussing or presenting about the Section 5, 9 and 10 of Married Women Act 1957. And our last presenter will be Ahmad Daniel bin Amir Saad and his matrix number is 281 and 507. And he's going to explain about the Section 11 and also discussing the case of Chin Shak Len versus Lin Fah. Between status and property under family law. So basically, status can be comprehending in the context of every married woman has the same remedies and redress in her own name against her husband for the protection and security of her property as if she owned it as a feme sole. So the terms of feme sole can be defined or can be interpreted into the concept of a woman without a husband, especially for those who has been divorced. Next, we're going to talk about the property, which is any physical or intangible entity possessed by a single person or a group of individuals is referred to as a property. An owner of the property has the right to consume, sell, rent, mortgage, transfer, trade, or destroy their property by depending on the nature of the property itself, and also can be prevent the others from doing so. 2 of Married Women Act 1957 said that married woman can be defined as any woman that married in accordance with the rites and ceremonies required by her religion, manners, or customs. And the terms of contract itself includes the acceptance of any trust or of the office of executrix or administratrix. And the context of property includes a thing we've been discussing in a action.
Moving on to the next provision, Section 4A is a new section which was added in 1994. This section is all about the capacity of husband and wife to sue each other for personal injuries. Under Married Women Act 1957, Section 4A provides that a husband or a wife shall be entitled to sue each other in tort for damages in respect of injuries to his or her person, as the case may be in the like manner as any other two separate individual. Furthermore, we will be looking at the relevant case under Section 4A of Married Women Act 1957, which is in the case of Yeo Bei Lin against Lee Eng Chi, 2004, 1 CLJ 691. In this case, the plaintiff had brought an action against her husband under Section 4A for the personal injury or loss of reputation and severe mental distress which was inflicted to her when she was forced to listen to his exploitation of adultery in detail. The court held that when reading personal injuries or injuries to his or her person in Section 4A, there can be no distinction between that of a physical nature and a mental variety, as both are within the meaning of the provision. Therefore, personal injury is inclusive of both physical and mental injuries, such as the loss of reputation and mental distress suffered by the plaintiff. In addition to civil action, a criminal proceeding may be taken against a husband or a wife for inflicting personal injuries on the wife or husband respectively.
Now let's move on to the property of married women. A married woman is capable of acquiring, holding, and disposing of any property, liable in respect of any tort, contract, or debt or obligation, sues and is sued in her own name, either in tort or in contract, entitled to all remedies and redress for all purposes, subject to the law relating to bankruptcy and to the enforcement of judgment and orders is if she were a female or an unmarried woman. So let's look at Section 5 of Married Women Act. Under this section, it provides about married women's property. Under this section, it stated that if the property belonged to a married woman or was held in equity for her independent or personal use, the property will belong to her in all respects as if she were a female or an unmarried woman. The property may be disposed of accordingly. Any restriction that does not attach with the enjoyment of the property of the woman will be void after the enforcement of this act. Section 6 of Married Women Act abolishes a husband's liability for his wife's torts and antenuptial contracts, debts, and obligation before or after marriage. A husband of a married woman shall not be liable on any tort committed by his wife, whether it happened before or after marriage. He also shall not be liable for any contract entered by his wife, debt, or any obligation incurred, whether it happened before or after marriage, just because he is the husband of his wife. In addition, he also shall not be liable to be sued or made a party to any legal proceeding brought in any matters of such tort, contract, debt, or obligation. Section 9 of Married Women Act provide about the right of the married woman for the protection of their property. Every married woman has the same remedies and redress for the protection of her property in her own name against her husband as if such property belongs to her as a female. A husband or a wife can sue each other in tort for the protection or security for their property. Any criminal charge or in any proceeding relating to the property of a married woman, it is sufficient to allege that such property is hers. There are three situations in relation to criminal proceedings against a husband or a wife. First, where the husband and wife are living together. Second, where the husband and wife live apart. However, the act complained of concerning property occurred when they were living together. For these two situations, no criminal proceedings may be taken by any of the spouses. The third is where the husband or wife is leaving or deserting or about to leave or desert the other spouse, and the act complained of concerning property occurred when they were living together. For this situation, criminal proceedings may be taken against the offending spouses. Section 10 of Married Women Act provide about wives' antenuptial debts and liabilities. A woman after her marriage will continue to be liable for all her debts and all contracts entered or wrongs committed by her before the marriage. It also includes any sums that she is liable as a contributory, either before or after she has been placed on the list of contributories under and by virtue of any written law pertaining to joint stock companies. That woman may be sued for any such debt and for any liability in damages under any contract or in respect of any such wrong.
Section 11 of the Married Women Act 1957, subsection 1 explains that any party may apply by summons or otherwise in a summary manner to any judge of the High Court in any dispute between husband and a wife as to the title or possession of property, or if the property's worth falls within a session court civil jurisdiction, the session court judge will hear the case. And the judge or session court judge may issue any order he sees fit with respect to the property in dispute, as well as the cost of the application, or he may order that such an application be dismissed, and that any inquiry into the facts in question be conducted in the way he deems appropriate. Moreover, subsection 2 explains that any order made under this section may be appealed in the same manner as an order made by the same judge or sessions court judge in an action ongoing in the High Court or Session Court, as the case may be. Lastly, subsection 3 explains if either party requests it, the judge or session court judge may consider any such application in his chambers. In the case of Chin Shat Land versus Lin Pa, the fact of the case is that this case concerns with Section 11 of the Married Women Act 1957, in which to question the property of undivided shared interest between a husband and a wife of their matrimonial home by a summons. So the applicant, the wife, has provided a total of $1,200 to the husband, which is the respondent, to buy a piece of land back in 1951 due to emergency situation during the time where the government ordered the applicant to move from the estate. So the husband advised the wife to buy a piece of land in which he asked the wife for an amount of $1,200 and that he will buy the land in her name. The husband provides his part amounting to $400 as well as with 3 other purchases of the land. The issue arises when the wife finds out that the land was not registered under her name and happened to know when the husband intends to sell the land. So the wife asked the husband to transfer the land proprietorship to her, but then was refused and he still intended to sell the land. The husband in his argument said that the $1,200 provided was merely a loan in which the husband has paid back by purchasing another plantation estate for the wife. The wife contended that she provides the money for the purchase of the land under her name. The proceedings were brought to the court to determine the status of the land in question. The court in this issue held that the amount of $1,200 provided by the wife was not a loan. The court also held that the title of the land shall be vested to the wife, and the husband only have 11 per 180 shares left. The court ordered a proper registering authority to make such memorial to give effect on the court orders. And lastly, the husband was also ordered to pay the applicant the cost of this application amounting to $350. So the grounds of judgment in this case would be that the court opined that well-settled law for a husband to buy a property and convey it to his wife as a gift is a prima facie. So there is no presumption of advancement where a wife provides money for the purchase of husband's property, and the husband only have 11 per 180 shares left on the said land, amounting to his contributions of only $400 and the sales of his few parts of the land previously in the previous years. So the court also of the opinion that the repayment of said loan amounting to $2,400 by buying a rubber plant estate does not amount to repayment of the loan, as it was an afterthought in which the husband does not declare the $1,200 upon receiving as a loan and only thought to repay it afterwards. And lastly, the court also finds that it is well-settled law when two persons advance purchase money jointly and the purchase was registered under one name, there is a resulting trust in which there is equitable tenants in common.
As for conclusion, every married woman has the right against her property and to protect it even from her own husband. However, it is important to note that if the woman commit any tort, enter into a contract, or face debt, the husband will not be liable to sue or be sued by the other party just because he is the husband of that particular woman. This will give justice for both parties, whether the wife or the husband.